Okay. Good afternoon, everybody. Don't touch face. Right. So, welcome, obviously, welcome to our COVID-19 webinar. We apologize for having to start late, but the Minister for Employment beat us to it in the sense that he launched a Facebook Live Q&A at 2:30, which obviously meant we had to move the whole thing by half an hour because otherwise we would have issues, which we did. So, thank you for everybody for being so patient. And I think we can kick off slowly. First and foremost, I have a low power on my earphones today, and unfortunately the charger is not with me. So when you are not hearing me anymore, if you can just raise your hands, as you know how to do it, you can raise your hands by the panel. And when you're not hearing me anymore, are you hearing me? Okay, thank you very much. Fine. Okay, stop raising hands. I know you're enjoying raising hands, but you can stop it now. Right, then let us just move on. So with me today, first and foremost, just way of introduction, I have Robert, and I also have Lara. I don't know if you're seeing them on your screen right now, but you'll be seeing them as soon as I give them the mic, so to speak. The way the system works, just for you to understand also, is that you do have a number of functions which you can use. One of them is the live chat. So there's a chat box which you can effectively chat into, and you can pass comments and give us your feedback as we go along. However, and this I have to highlight, do not, please, I almost beg you, do not ask questions as we go along, because they are obviously quite distracting for the person who's trying to make his presentation. That being said, at the end of a very short presentation, you can ask your questions by typing them into the Q&A box. So effectively, you all should have access to a Q&A box, which you can put your questions in, and at the end, we will go over the questions that you asked. Moreover, I would like to thank very much all those people who have sent me their questions via email, and hopefully we'll be able to tackle those as well. Some of them, the ones which are general. Some of you did send me some questions by email which were pretty specific, so unfortunately we can't go down that line. But we will be contacting you, and then we'll take that discussion forward. However, if you have asked a general question, we'll be more than happy to answer. The landscape so far has been changing into one which is constantly changing, and I mean constantly. So it's very important that whatever we say today may change tomorrow. I know it's confusing. I know it's really frustrating. It's frustrating for everybody. But what's happening is that we have a real live epidemic, which is effectively creating rules to be changed on a day-to-day basis. That being said, we have, thankfully, since we live in a small country, we have good contacts with the government departments, and hopefully we have gathered all that we need to say in terms of the benefits and everything else, that you'll be able to actually move ahead without worrying about, all the, not fake news, but all the misinformation, because there's a lot of progression from a day-to-day basis. So I think we can begin, and obviously I hope that you enjoy. Okay, so starting off from the first slide, I will just give me a moment, change that in a second. There we go. And I give the word to Laura now, who will basically take us.
So, hi, I'm unmuted now. So good afternoon to all. We wanted to start, before going into the benefits, to just look a bit at the quarantine leave notices which have been published in the last few days and few weeks. So I wanted to start with the quarantine leave, basically just to refresh a bit what we have, Matthew has spoken to you about in the last webinar. Sound is not good. There's a comment. Okay, I can continue. Okay, so I have to go louder. I continue. Okay, so yeah. Okay, can you hear me now? Is it better? Yep. Okay. Thank you. Okay, so just to repeat what I said, we wanted to go into a bit what quarantine leave is all about, just for you to refresh a bit the last legal notices which have been published. So, when does quarantine leave first apply? So, anyone who arrives from another country entitled to quarantine leave. So, the rules on mandatory quarantine leave came in on the 12th of March. So all employees which arrived to Malta after the 12th of March on or after were required to spend 14 days in mandatory quarantine leave. So all employees who actually came into that date, the special mandatory quarantine leave would apply. In terms of payments during this mandatory quarantine leave, what does the employer have to pay? And the legal notice is quite clear on this. The special leave legal notice is quite clear that the employer needs to pay basic wages. So anything which is not required to be paid during a period of quarantine leave. So our last question on quarantine leave, just as a brief overview. So if an employer is living with someone who has been quarantined, so because they traveled and then when they arrived back to Malta, they have to be quarantined, are they entitled to quarantine leave? And the answer is yes. An employee who is living in the same residence as someone who has been quarantined is entitled to quarantine leave for a period of 14 days. Just to close the quarantine leave sector, it is a leave which is given over and above vacation leave. So it is a special leave which is not deducted from the vacation leave per se, but is over and above vacation leave. Okay, next slide. Okay. Mhm. Okay. Recently, we've heard the Minister for Health also issue a press conference on vulnerable persons, and then a legal notice was issued exactly on this point. Now, vulnerable persons are defined in the legal notice per se, and these people who are considered to be vulnerable person need to remain in segregation, and they can go out for limited circumstances, but they need to remain in segregation. And the legal notice provides a whole list of who is considered to be a vulnerable person. I am not going to go through all the list, but just to give you a few examples, persons over 65 are considered to be vulnerable persons, pregnant persons, patients who are on insulin, patients on dialysis, patients who are suffering from cancer and who are undergoing chemotherapy. So if you fall within the brackets, the definition defined by law, you are um, you are considered to be a, a vulnerable person. Now, our next question is quite interesting and it links to quarantine leave, which we have discussed in the previous slide. Is a vulnerable person entitled to quarantine leave? Now, from the way the legal notice is actually written, and at this stage, we would say that no, a vulnerable person is not entitled to quarantine leave. So if a person who is considered to be vulnerable needs to remain segregated at home, if the person can work remotely, Okay. If the person can work remotely, then that person continues to be paid normally as though he were working from the office. But if the person needs to be segregated because of him or her being a vulnerable person, but such person cannot work remotely, then the employer needs to consider all other options. At this stage, it's possibly the using of vacation leave, which has been accrued, and then putting the person on unpaid with the possibility of applying for a benefit. Now, individuals living with vulnerable persons, are these entitled to quarantine leave? Now, the legal notice per se makes no reference to persons living with vulnerable person, and this has been confirmed by the minister in his press conference half an hour ago. Individuals who actually live with vulnerable persons should go to work normally, unless they can work from home. Now, how should our last question on vulnerable persons is how should an employer deal with individuals who actually want to remain at home, whether they want to take care of a dependent vulnerable person? Now, the employee should not and cannot unilaterally decide that they do not want to attend to work because they are taking care of a dependent person. So arrangements need to be made with the employer, and it's up to the employee's discretion to allow this, especially when the person cannot work remotely. So most probably in this case, like the vulnerable person, the employee would need to use his accrued vacation leave and then apply for Now, just as a point of closure with respect to vulnerable persons, we haven't yet confirmed this completely, but we are of the view that when the vulnerable person cannot work from home and is required to stay at home, then that's once the vacation leave, the accrued vacation leave is used up, and the individual actually is is required to go on unpaid leave, then there is no authorization required from the department, because that stems from the legal notice itself and is not, the unpaid is not being actually um, required by the employer to avoid redundancies. So in that case, we think, and at this point, we feel that no authorization should be required. Mhm.
Okay, thank you, Laura, for that. We will now continue with the presentation in relation to the next phase, which is the so-called approach to the DIER. This is important because people are getting lost in the benefits part, and they are forgetting that in this whole story, there are two main parts which go together. And this is something which I would like to spend some time on, so that we all understand exactly how things work. The thing that is effectively happening right now is that you have employers who, for some reason, well, basically it's the reason, which is effectively COVID, right? Those cannot pay wages anymore, or would like to introduce certain measures in order to avoid redundancies. That is and lives totally in isolation from the benefits regime. And the piece which I'm mentioning now, and show the piece on putting in place measures to avoid redundancies, is dealt with and needs to continue to be dealt with in parallel with the benefits part with the Department of Industrial and Employment Relations. This is essential because people are forgetting. They are going straight for the benefits part and they're forgetting their obligations in terms of the Employment Act. When you are an employer and you want to introduce certain measures, you have to, or you might have to, do one of two things. And this is completely independent, again, of the benefits part. The benefits are something which are separate to this. So let us start from the things which you can do without the department's permission. And again, this is totally dependent of the benefits. So as an employer who has benefits or who doesn't make a difference. You can do these things that I have now on the screen without any permission whatsoever. The first one is you can force the vacation leave that has been accumulated up till today. So you can tell your employees, the leave which you have right now, take it. I don't have work, take it. Okay, you do not need permission to do that. What you do need permission for is to tell the employees that you would like them to take the leave which they haven't yet accumulated, and therefore the credit, what we call so for example, the leave from now till December. You can tell your employees, although you haven't earned that that leave, I would like to give it to you now. I'll give it to you now in terms of being paid as well. So obviously you need to have the cash flow for this. But essentially, if you want to do that, you need permission. If you want to force the leave, which is just what has been accumulated or carried over from last year, because they're in one basket, that you can force. All you need to do is send a message to your employees why, and obviously put it on the COVID situation, and that should be enough for you to implement it. Okay, there is no permission needed in that respect. You can also implement a wage freeze, obviously. So you can say no wage increases from now until whenever you want. That does not need permission. Here, a word of note, and this is why I have the text on the screen, which is when you effectively have a collective agreement or a signed document where you have actually bound yourself to have increases, in that specific case, you cannot get out of it without the permission of the Director of Labor. So if you have no promised wage increases, you can obviously have a wage freeze nonetheless. If you promise them in terms of having a written agreed document, including a collective agreement, you would need to go to the Labor Office for permission. The last one, which there was also some confusion of in relation to the Labor Office issuing some communications to the contrary, let us be clear, all bonuses which are discretionary can be stopped by the employer. No questions asked, not an issue whatsoever, no permission needed. Okay, if you have performance bonuses, production bonuses, whatever it is, where effectively you are you have promised that there is a scheme in place, but now you have no cash to give them out, those you can stop. What you cannot stop is the government bonus. That is something which you cannot stop without permission. Okay, now moving along, let us see now where you actually need permission. So here's where you don't need permission. Where you need permission is this situation. Now, how is the permission asked and what happens? I'd like to, let's take a step back and let's see where you need permission, and then I'll go on to that. So you need permission if you are going to go on unpaid leave, or you want your employees to go on unpaid leave. This can even apply to a section. So all the remedies we have here do not need to apply across the board, except for one, which I'll get to. But the unpaid leave can even be applied to a section of the company where you're having difficulties. Now, in that situation, the whole point is that you are going to ask the Labor Office that you would like your employees to go on unpaid leave. That means that from your end, you will be paying nothing. And this is important because it links into what the minister even said now and all the confusion on the employer top-up. The employer top-up situation has raised a lot of confusion. But essentially, and this we'll get to now when we speak about the benefits, the important thing is that you can get out, or you should be able to get out on paying anything as an employer to a section or all of your employees if you apply to the Labor Office for such a permission. The condition which is being imposed when you do that is that you will have a situation where they will tell you, first go. You can hear me? First go on forced leave and then go on unpaid. I'm getting some complaints on the sound, so I will talk slowly because the bandwidth is not exactly ideal at this point in time. And I do appreciate that since we have more than 200 participants, it's going to be tough for Zoom to cope with us. So, so bear with us here. Right. Then the next point that we have is the reduced hours. This is also something which you can apply for the whole company or for part of the company, and it needs to go via the DIR as well. Thirdly, is the removal of fixed allowances. This too, together with any fixed payments that you have to give, for example, in a car cash allowance, any other allowances which are fixed and are non-discretionary, those need permission to be removed. Okay, so you can actually go and apply for them to be removed. The last part and the last circle which you see on the bottom is the overall wage reduction. Now, this is something which initially the Labour Office has resisted. However, we have, and when I say we, I say as a lobby group, I'm the president, well, president is not the word, but I'm the president of the Malta Employment Lawyers Association, and we have lobbied so that this matter is revised. And thankfully, they have revised it. They have revised it in the sense that if you are a company which has, let's call them living parts which are doing well or doing okay, and other parts which are not doing so well, at that point, you can apply with the Labour Office to get an overall wage reduction, which needs to be over all the company. You cannot apply for just a particular section to be going down as a wage reduction. The approach of the Labour Office is that if, as a company as a whole, you are not doing well, and then apply for reduced hours or for unpaid. The wage reduction idea is only there for those companies who have a situation where some are doing well, others are not doing so well, and therefore the DIR may take an approach of that, since the ones who are effectively there to support the others, then that can happen. Let me give you an actual specific example which has been raised more than once, and this is very, very true. The gaming industry. The gaming industry has been hit hard on sportsbook because obviously the games stopped, much to my wife's pleasure, not mine. But effectively, then now they are doing very well on the casino front because people are at home and have nothing to do, and therefore gambling is, or rather, sorry, gaming, as they say, no gambling. Gaming is what people are actually enjoying right now. So in that situation, a gaming company can say, look, we don't want our sportsbook guys to suffer because of the rest, because they are in trouble. We don't want to apply for them to be on reduced hours, whereas the rest of the company is enjoying life and earning money. Enjoying life, obviously, I'm just being silly, but you know what I mean. The idea is that if that sort of company goes and asks the Labour Office for everybody across the board to take, for example, a 10% wage cut temporarily because of COVID, rather than making that section go on reduced hours or unpaid, then that's something which the Labour Office will consider. Now, this brings me to what to do and how to do it. it is very, very important, and I can't highlight this more, that the applications that you make via the Labour Office, which are effectively done via email, there's no online portal like the one of Malta Enterprise, are done by a professional. We, as employment lawyers, are meeting on a daily basis to cross notes, make sure that there aren't problems, to make sure that your application goes as fast as it can. Applications can take between 2 days and 2 weeks. If you want to be on the 2-day side, do not write in yourself when you don't know what is being changed on a daily basis. And I know that now is not the time to spend money on your lawyer, perhaps. And I'm not telling you all to come to me because we can't even cope. But what I'm telling you is do get professional advice. Because I have had people who have come to me when the Labour Office have told them no. And then it's very difficult for us to make them change their mind. Okay, so please, I beg you, this is really a general appeal, do take proper advice before sending in your request, because there's no online application. It's all effectively put down in an email, and it's up to you whether you're going to get 100 questions back and never get there, or it's effectively get your application quite fast. Okay. Now, the way it works is that you send in an email, you as I said, I would recommend your professional advisor, and effectively the email is then processed by the Labour Office. There is a very important point which the Minister also mentioned on the Facebook chat today, which is what to do before you send the email. The section which is relevant and which we saw in last time's webinar is section 42 of the Employment Act. All right, and this section specifically says that in order to go and to apply to the Labour Office to avoid redundancies, what you would need to do is get an agreement from your employees before. Now, what does this agreement mean? Is something which we would need to debate with every single company which is effectively going to apply. But generally speaking, what it means is that you need to get a general consensus, let's say, I would say definitely a majority consensus from the employees of the company or from the workers' reps if you have them, or if you need to have them. So all companies with 50 plus need to have them. So that effectively what you are doing at this point is that you are getting positive feedback that the measures that you want to implement are okay with them, and then you apply. You cannot forcefully apply.
My sound's gone. My sound's gone. 1 second, I have to change. You can let me the earphones now. لا let me the earphones. أنا هلا. You can hear me now? Plug this back in. Okay. I'm going to continue like this. I'm just going to take away the echo. All right. Are we all okay? Because very good. I'm sorry about that, but my earphones went gaga. Okay, so the way that, so rather what I was saying is that when it comes to permissions, you would need to get the employee, what we call employee engagement. And this is actually very important. Now, once you get it, you apply. You get the application through, and you get what permissions the Labour Office wants to issue. The permissions can actually vary. They can vary from one point to the next, one case to the next. At the beginning, because this is important from a historical perspective, what happened is that when we went with the first application, they replicated the response to that application to a number of others. And then the DIER, because they too were caught in this whole mess effectively, had to even, they had to evolve even on the applications. Now they're at a point where each application is being seen on its own merits. this even ropes into the famous employer top-up issue, which the minister also mentioned, and which was first mentioned by the Prime Minister and then got lost somewhere in space. Now we know exactly where we stand, even in relation to that top-up, and I will get to it when we come to the benefits part in a minute. Okay. Right. So I think now what we can do and what we should be doing is roping in Robert. So we go to the benefits part. Just 1 second, and I will. So before I bring in Robert, and I can actually start by bringing him on screen. Hi, Rob.
Hi everyone.
Okay. So as you guys are now seeing on screen, these are the benefits which are now being offered by Malta Enterprise. So as I said, the DIAR is now, let's say, out of the window. We've gone there, we have now applied for our permissions. Now is the time to look into benefits. Mentally, I think that you need to start off from the DIAR first and then get the benefits later, because people are rushing towards the benefits. So they're trying to grab what they can, forgetting the actual permissions of the DIAR, which are very important. So the benefits are essentially the ones that you can see on the screen. What I'm going to do now is that together with Robert, we're going to quickly run through the benefits table, which we have prepared for everybody to see. Just for you, for those of you who want to actually download this, you can find it by going on our website, and I will show you exactly where. All right, so as you can see here, we have the benefits table. All right, this is available online, and you can effectively go through it. So let us go through it slowly with Robert. I'll try and make it actually a bit bigger so we can go through it together. So the benefits, okay. All right. Robert, in your hands.
Okay. Well, in the first place, there is a taxpayers qualifying taxpayers have been given an option. It is an option to defer the payment of tax falling due, certain qualifying eligible taxes falling due in March and April of 2020, subject to submission of an online application by the 15th of April of 2020. And the option is available to companies and self-employed, provided that they have one, satisfied all their tax obligations falling due up to the 31st of December of 2000. And in addition, they have evaluated, or at least made their own assessment in their own minds, they have suffered or will be suffering a significant downturn in their turnover and sales, and therefore having substantial cash flow difficulties. Now, the guidelines aren't entirely helpful when it comes to this area, so each one is left to his own devices to make that evaluation on the downturn. The guidelines suggest that a downturn of 25% over a 3-month period should represent an acceptable downturn and eligibility, therefore, for the tax deferral. The tax is covered, importantly, or provisional tax, FSS, final settlements, security, social security contributions, and even VAT. But VAT, this is VAT falling due in March and April, so not VAT. So a VAT quarterly return falling due in one of those 2 months, not VAT collected in those 2 months. So to the extent that most taxpayers have a calendar pay VAT or report on a calendar quarter basis, this shouldn't we shouldn't see a widespread application of that VAT deferral. But the benefit, of course, in the deferral is that the tax falling due, so provisional tax falling due in April, will be deferred, and no interest and penalties is payable. The sting in the tail is that if an application is made and on the basis of the taxpayer's own assessment that he or she is suffering a significant downturn, and then for some reason, presumably revenue have left the door open to dispute that, and if that does happen, tax will have been paid and interest and penalties will accrue. Otherwise, if there is no problem, the tax that falls due in those 2 months will be paid in 4 installments, in equal installments from May to August. This is what we have so far. Do you want to go to the grants, Matt? You're muted.
Yes, Rob, let's move on, otherwise we'll get stuck. So focusing quickly on these 2 grants. They're pretty self-explanatory, mind you, but from what I understand, Rob, correct me if I'm wrong, the teleworking cash grant is a maximum of 4,000 per company. It's for those companies which purchase some equipment, for those who effectively want to telework. So I think it's pretty simple. Those of you who want to effectively apply, the links are there, and go ahead.
Yeah, provided the costs are incurred after the 15th of February.
Yeah.
So anyone who made arrangements beforehand won't be eligible for these grants.
The only thing which you have to watch out here is that a teleworking agreement needs to be signed with every employee if you do want to go for these grants.
Okay.
All right, then the mandatory quarantine grant. This is the famous one-time $350 for the 2 weeks of forced quarantine. There's an application online which you can follow by going on the link, and it's pretty straightforward, I guess, Rob. Nothing complicated here. You want to say something?
No. Nobody else.
Right, now let's get to the gist here. This is obviously the famous COVID wage supplement, which everybody is talking about right now. So this is the main thing. Now, let me start off by explaining some basics, and then I'll leave it up to you, Rob, to explain how the payment system will actually work. So the way that the system works is that, independent on the permissions which you are getting from the DIER, if you fall in the annexes A or B, A are the most hard hit and B are the, let's say, the second tier of hard hit companies, there you can apply for the COVID wage supplement. Those which are not in the list cannot apply for this. Unless, and this is important because Malta Enterprise has changed its approach here, unless you can make a case. Now, what is making a case? Making a case means that you do not fall in the list, but you are in an activity which is similar to those on the list, and you can prove, just as Robert was mentioning, that you have made such a loss, or you are going to make such a loss, and you have no cash flow to pay your employees, that you would like to apply anyway. And Malta Enterprise is still entertaining such an application. So let's not sort of freak out and give up because you are not on the list. The problem is that that is only by way of exception. So let me give you a very clean example. If you are a gaming company and you feel that you want to go for a benefit, which means that you are not on the list, effectively at that stage, you would need to try to make a case. Malta Enterprise is accepting your application on a case-by-case basis. All right, so it's not a yes for sure, whereas if you are listed in the annex, you will get it for sure. But it is rather, you need to make your case. Now, what happens if you are listed in Annex A. If you are listed in Annex A, your employees should be receiving a grant which you will be applying for. So you go on the online system, we have the link over there, and you apply on behalf of the employees who are affected. They could be all the employees or some of them. It's basically up to you. At this stage, the way that multi-enterprise are actually approaching this is pretty straightforward. They cannot and will not go into every single case and try to see whether the employee should be getting the full amount or less or pro rata, etc. They have classified the employees that you are going to basically apply for in two simple categories. And these are linked with the Jobs Plus registration. So if your employees are registered with Jobs Plus as full-time or whole-time with reduced hours, they will be getting the 800 euro grant per month. All right? No questions asked. If they are part-time, registered with you on Jobs Plus, they'll be getting 500. Now, the obvious question is, if I have more than one job and I'm registered with more than one employer, can I get double? No. The guidelines are very clear in that you will only be getting the maximum. So you cannot get 2 grants from 2 employers. You probably get it from 1. Now, which one is basically what happens is that the employer will apply with your ID number. So the enterprise would then compare if they have actually cross applications. You should apply for benefits, or rather your employer should apply for benefits for you if the employer is paying national insurance. All right, so if the employer is paying national insurance for you, that should be your principal employment. And therefore that's where you should basically go for the benefits. Now, let us move on to see what is happening then in relation to the benefit itself. Rather, sorry, before we go there, let us discuss and clear once and for all this confusion or semi-confusion on the employer top-up situation. Does the employer need to top up the 800 euro or the 500 euro with something else if they are in Annex A? If you are in the Annex A and you have no permission from the Labour Office to reduce or go on unpaid, the MCSD has come to an agreement where you should be trying to pay at least 400 euros over and above the 800. However, if you have a permit from the DAIR to pay less or to go on unpaid, you have no obligation to pay the 400 euros. So if you have not applied to the DAIR and you're going only for benefits, you would need to try and top up by 400. But the DAIR can give you a dispensation so you don't pay that extra 400. Okay? This needs to be made clear so that everyone understands, because there's a lot of confusion. Now, let us discuss, Rob, and now I'll leave it up to you, how this famous 800 or 500 is going to be passed down. Actually, sorry, before I go there, if you are now on Annex B, or you have been placed in the equivalence of Annex B, what is happening is that with Annex B, as you can see from our wage supplement 2, 3, etc., if we go down, they're all like that, all right? There is effectively a payment which is being given. Now, the Malta enterprise has made it clear that in order for you to actually get that grant, if you are on Annex B, in that situation, you would need to top up. And it is a condition for benefits that you do top up to the 800. I'm going to show you where this thing comes from, so effectively we will basically understand. In the guidelines of Malta Enterprise, which I'm going to show you right now. So once you get here, you would need to go on the application form bit. And that's where you get the notes to applicant, which are extremely important. On the notes to applicant, you see number 8. Number 8 refers to those who in Annex B or are getting a COVID wage supplement less than 800 or less than 500, according to whether you are classified as full or as part-time, okay? What happens is that if from the government benefits, from the government grants, your employees, because you are now on Annex B and therefore you're getting less, are getting less than the 800, you have to top it up until the 800. Now, why are you seeing the number 720? Robert, now I leave it up to you to basically go over this. But the 720 relates to the fact that the methodology of payment to the employee is something which reduces the number from 800 to 720. Rob, if you want to explain, I'll leave it up to you.
Yes, okay. The payments are made via the employer. And the employer is then required to pass those payments on. But there is a deduction at source for national insurance. And then the employer is required to pay his share of the national insurance as well. From a reporting perspective, there's a bit of an anomaly, because in terms of these guidelines, if you're looking at item 15, the COVID wage supplements are non-taxable, but it's not entirely clear as to whether that means they fall completely outside the scope of tax altogether, or whether in fact they are non-taxable because they should fall within the zero rate on our progressive tax system. So to the extent that they shouldn't exceed, if that is all you're earning, the zero rate. So that's not entirely clear. This is an issue in respect of any person who is earning, let's say, 800 and then earning something else on the side. If there's some, whatever, for a delivery driver, for example, who's earning his 800 because he was a waiter in a restaurant and is now handling deliveries and earning a few thousand a year, is his income the 9,000, whatever, 600 plus the few thousand he's earning, or is it just a few thousand, in which case he's not going to pay tax on anything at all?
Rob, let me just stop you there for a second. People might get a bit confused. Obviously, people like us, the mere mortals who don't deal in tax, tend to be a bit more, green on this. But let me start from the example which you mentioned, in fact. So let's start from the restaurant example. Now, restaurant would typically fall under Annex A, all right? So let's say I have a restaurant which has been shut down because the government told me close your doors, nobody in the restaurant, and yet I am still doing deliveries. Now, in that scenario, what's going to happen is that I'm going to apply for my employees for the COVID wage supplement. And depending on whether they are registered with Jobs Plus as full-time or part-time, they'll be getting the benefit. Let us take one full-timer as an example. So the full-timer will be getting the 800 euro grant, and now you'll explain how that works, right? But if they're getting the 800 euro grant and I still need him for deliveries, I would still, and this is important for people to understand, I still need to pay him for the work he is doing. I cannot say, because you were getting the grant, I'm not going to pay you, all right? This is something which people are getting very confused on. If you are actually going to make people work, you need to pay them. So then the option is that if I have somebody who's used to work 40 hours and is now going less, or is 40 hours and is now going to reduce to unpaid because I have no work, and then you go to labor office and you apply for that. But if you are on reduced and you are still working, the employer needs to pay you for that work. Now, and this goes back to you. If we are now working a little bit, and therefore you have the delivery man, let us take it step by step. So the grant that he is getting from Malta Enterprise, how is that processed? Let's start from there.
It's paid to the employer, and the employer is then required to immediately, or as soon as reasonably practicable, pass the payments on to the employees.
Now, how do we get from 800 to 720?
That should be a deduction at source for national insurance.
Exactly.
So that's deducted.
Okay, so effectively what the ME is doing is, it is getting the 800, it's removing the NI portion of the employee, which is 80. And it's giving you, as the employer, 720.
Which you are then required to transfer to the employees.
Okay. And let us be clear, over and above that, the employer needs to pay his portion of NI now as well.
Exactly. He has to top up his portion.
Okay, now, that being said, if the person is completely unpaid from an employer's perspective, that's it, he stops there. But if the employee is now working, because I'm giving him some deliveries to do, right? In that situation, the extra payment needs to be taxed normally, obviously.
This is it, but taxed from, we don't know what the starting point is yet.
In terms of brackets.
Point, exactly, is the starting point 0, because we ignore the COVID wage supplements completely. So any extra is taxed accordingly from 0. Or do you top up that income with the grant, the wage supplement, to see which bracket you fall into? Anything over 9,100 is in the 15% bracket, single rates anyway. Then there are the deduction rules to ensure that anyone on a minimum wage isn't actually paying any tax. But so essentially, anyone, if this goes on for a year and you have an employee who is earning 800 net, 720 per month, they won't pay any tax. That's clear. But that would work either because Malta Enterprise wanted the grant to be completely outside the scope of tax, or because they're not quite outside the scope, but if that's all you're earning, then you're in the 0 bracket, so you don't pay any tax anyway. So
and
then
where are we on this with the IRD, do we know?
When I spoke with them this morning, they didn't seem to know. They're discussing it.
Okay. So obviously, it's a matter of watch the space and then we see, of course.
Yes. Even they're watching the space, apparently. They were taken a bit by surprise. So
Well, we take it slowly anyway.
okay.
All right. Now, Rob, let's go back over here on the, where are we? 1 second. Yep. All right. So, as we can see, then these are the famous wage supplements. Just for me to be clear once again on the employer top-up, because people are getting confused again. The employer top-up works like this. I'm going to say it slowly so we get it all of us. As an employer, if an individual has a wage of 1,500 per month, to give you an example, I am obliged to give him that wage unless I get permission from the DIR to reduce that wage. In the sense that I reduce the hours of work and therefore the wage is reduced accordingly, or else I get permission for the guy to go on complete unpaid. That's number 1. Number 2, if I don't do that, I still have the obligation to pay him his wages. And if I don't do that, then I still have the obligation to pay him the wages. Malta Enterprise is going to not tell me anything, but my legal obligation, as agreed now with the MCSD, we'll get to the next point, is that I have to pay him whatever difference there is between the 800 and his wage. Because otherwise, not the confusion. If you don't have permissions from the DIR, you have to keep on paying as you should. Therefore, you pay the wage now minus the benefit. All right? And so far, so good. Now, the MCSD have apparently agreed that one should really try to pay at least 400. So if you are going to pay, or if you cannot pay more than 400, And then Malta Enterprise will close an eye, apparently, if you don't have any DI permissions. But this is a dangerous thing to say, because from a legal point of view, you cannot simply not pay your employees or agree to pay them less for them working the same hours. So to avoid any kind of confusion, I should always say, apply to the DIR, see what permissions you get, and then from there, you will know how to apply the benefit situation. Because you cannot go to the benefits first and then go to the DIR afterwards, because you'll be all confused. Start from the DIR and then go to get the benefit stuff. You can apply for the benefits from now, but then the way in which or how you're going to pay your employees is very much dependent on DIR permissions. So like this, we are clear and we have no confusion. Well, no confusion for now. So the COVID wage supplements are all described over here, and obviously thank you, Robert, for explaining them. And now we go into the last part of the benefit section, which is effectively bar the unemployment benefit, which is linked with obviously with Jobs Plus. We will now go on the issue of the other benefits. Okay, now the last two benefits, Rob, seem to be coming out of Social Security. So here we have employees who will apply directly for this benefit from Social Security. Do we have any responses into whether this will be taxed or not, part of their income or not, or wouldn't you know at this stage?
No, nothing yet.
Nothing yet. Okay.
No.
Let's assume that for now, this is effectively, well, it is being discussed as being a benefit for the employee. So it's similar to a sickness benefit or an injury benefit coming out of the Social Security, right? So
one assumes.
How does it work? Let us start from the easy one, which is the parental benefit, or rather, sorry, which is the medical benefit. The medical benefit would apply to all those persons who have been earmarked as vulnerable by the government order. So we have a legal notice, which is 111 of 2020, which has listed which persons are deemed to be vulnerable. And all those who are not on the pregnant list, because the government doesn't know everybody who's pregnant, obviously. And all those who are 65 plus know who they are, the employer knows, it's obvious. But as for the rest, those who have medical conditions, they should be receiving a letter at home telling them whether they are actually earmarked to be vulnerable or not. By now, people should have actually received it. Those persons, because they are not eligible to any quarantine leave payment, because on those persons, therefore, you can't even go for the 350 benefit, all right? They would need to apply for the so-called medical benefit. So the vulnerable persons themselves, not those living with them, I'm not confused, the vulnerable persons themselves will be entitled to apply for the medical benefit directly with the Social Security. And on the table, you have the link, so you can go and see how that works. All right, now, as Lara explained before, from an employer's perspective, once somebody is deemed to be vulnerable, really and truly, the employer needs to come to arrangement with the employee as to how that person is going to be paid or not. That person does not have to be paid. It is not the responsibility of the employer to give full payment as would happen with quarantine leave. All right, this is a very different situation. So in this situation, effectively, what's happening is that the employee, because of a government order, needs to stay at home, and the employer is not there to foot the bill. The employer, however, can, if he wants, of course, pay the employee what he feels is adequate, or nothing at all in the extreme. Let's be clear. This is why there's the medical benefit for the individual to effectively go for. On the parent benefit, this is the one where there was a bit of confusion, Rob, in terms of, you know, one parent, two parent, etc. I don't know if you want to give a bit of a description as to how this one works, or I'll do it myself to you.
No, it appears that you have the parent one is we have two parents working in the private sector with children at school, where they have to stay at home to take care of of the children, but cannot work remotely. This is my understanding.
Okay, so in that case, they can also apply via the portal. You have the link over here, so they basically apply, and they would get the parent benefit. All right, I see the questions are obviously climbing. We will get to them very, very shortly. Again, please keep on using the Q&A section, not the chat, because otherwise we may lose track, okay? So if you have any questions, please post them in the Q&A section of the webinar. There's a Q&A panel, which you can see if you basically look at the controls as to what you can do. All right, let me go back to the presentation now quickly. We can continue where we left off. 1 second. All right. Okay, and I'm going to give the word back to Lara to quickly guide us through a couple of issues linked with remote working and data protection. Lara, if I can just ask you not to take more than 5 minutes because we are running out of time, unfortunately. 1 second, let me put you on. Rob, I'm going to mute you for now, and then obviously please be available for the FAQs.
Hi. Okay, we've been receiving a couple of questions on data protection and remote working, especially on monitoring. So I'd like to start with that. Since a lot of people are working from home, a lot of people have been asking us to what extent we can monitor and what kind of monitoring can we undertake. In this context, the data protection regulations still exist. So GDPR is still in place and still enforceable. Monitoring, as per GDPR and case law, needs to be done in a reasonable and proportionate way. One of the questions we have asked whether monitoring by taking screenshots of employees actually working, whether that would be considered to be reasonable and proportionate. And we think that that is, for example, an overstep. So we would suggest that you communicate with employees transparently as to what you are monitoring and how you are monitoring. Okay, I don't know if it's better now. Okay. Okay. I'll start from the beginning. Okay, sorry. Okay, so we've received a lot of questions on GDPR and remote working, and we wanted to start by focusing on that. To what extent can employees monitor, whilst employers monitor whilst employees are working remotely? Obviously, GDPR remains in vigor, so it's not that we have, because we're in this situation, it becomes completely unenforceable. To be done in a way which does not breach the employee's privacy. So, for example, one of the questions we often receive is whether the employer can take screenshots of the employee's screen whilst they are working remotely, and we are of the view that that, for example, is way too much and way beyond what is reasonable. So, simple monitoring of usage of internet, or there are methods which are less invasive, are advisable at this stage. We also suggest that you communicate with employees openly, in the sense that you tell them what you are monitoring, what data is being collected, how it is transferred, and how it is being processed. My colleagues who work in data protection, Philip Mifsud and Philip Formosa, wrote a very good article which is uploaded on our I strongly suggest that you have a look at that because it goes into the detail of monitoring quite accurately. So just have a look at that, and if you have any further questions, just get back to us, and we will revert. We will speak to our colleagues in data protection. With respect to quarantine leave, we also were asked frequently whether you could obtain any documentary evidence, or when vulnerable people request to be segregated, whether employers can ask for documentary evidence. And of course, the answer is yes, but again, proportionality is key. So you cannot ask for anything which is over and above than that what is necessary. So a medical certificate, a boarding pass, you don't need a whole medical history, but perhaps a medical note, or perhaps even the letter which would have received at home from the government, where the government actually tells them that they should stay in segregation because they are considered to be vulnerable. The last question on data protection, which is quite interesting, is can you as an employer disclose that one of your colleagues actually tested positive to the COVID-19? And in the circumstance, we would say yes. The employer has an obligation to make sure that the health and safety of all other employees is being safeguarded. So you can disclose just to make sure that all the tracing by the public authorities could be carried out. So for the interest of the employee's health and safety and for the public interest, disclosure is permitted without going to the extent which is obvious. Someone has tested positive and whether any contact has been made with that employee. Okay, that's all from my end. I think we've dealt with everything from data.
Thank you, Lara. Let me just quickly. So, thank you, Lara. Thank you very much. Okay, now comes the fun part. So this is the part I'm sure most of you have been waiting for. And we're going to do our best to try and, answer your questions as much as we can. Are we okay, generally speaking, with the sound? If you can raise your hand if it's okay and you can hear me. Because, all right, okay, stop. Thank you very much. Thank you very much. Because we are having problems with the bandwidth a little bit. So we're going to do our best in this respect. Okay, so I have on my Q&A box, I have 73 questions, which is no joke, obviously. I mean, we are not in a position to answer them all. I would like, before I even start, just like to pass on a message. These webinars are obviously free, and the way we work is that both our clients and our non-clients are here together today to try to understand what's going on as one big family, so to speak. We have received your emails and we thank you very much for sending them over. We are also receiving the questions. I will try to answer some of them, but of course I can't answer all of them. What I can tell you is that if you are a client, obviously we will then get back to your question individually, all right? So please be patient. One other thing, that if the questions are too specific to yourself, we are not in a position to answer them here and now. So the whole idea is that we answer the ones which would apply to a broad spectrum of people who are listening. So in that case, we will get back to you and then we will discuss what happens from there, okay? So obviously, I mean, thank you for your patience and even more so for your interest. Okay, let us start to go over the questions which were asked, and I will try to answer what I can, or if not, I'll pass the word on to Lara or to Robert. So, just one moment. Okay, the first question, which is relevant to everybody, is, and guys, don't worry, you don't have to stay on, asking questions anonymously. We will not be disclosing any names to anybody, so it's fine. But the first question is, is an employer who lost significant revenue but does not fall under any of the categories, rather doesn't fall in the Annex A or B of the benefits list, still eligible to apply for the wage supplement? As I mentioned, the answer is yes, but only by way of exception. So the government is actually, by the government I mean, Malta Enterprise is indeed entertaining certain applications from all those who are even not in the annexes, but you would need to prove your case, and it is not going to be easy or automatic. If you fall within the Annex A or B, automatically you are getting the benefits, which is always different. Right. Let me go on to some more questions. Okay. An interesting question is, how many instances of quarantine leave, and we have 14 days per instance, is each individual actually entitled to? Now, this brings a lot of confusion because it's almost, well, let's say, very difficult to have more than one quarantine leave period, because the quarantine leave is only available for those who have flown in from 12 March onwards, or for those who were already on quarantine leave forced by government, and probably it's only the ones coming from Italy a few days before, whose forced quarantine was continuing. So effectively, I don't think that anybody should be in a position to claim more than once. However, if you do have someone who came back after 12th of March, did his 14 days of quarantine, and then went back out for some reason, if he even could, and then came back in, well, then he would need to do quarantine again, yes, and you would need to pay more than once. It's a very rare occurrence, though. Now, a very good question relates to what happens to people who are stuck abroad. So if I do have people who are effectively stuck abroad, and the question is, would they be entitled to the same quarantine leave? The answer is no. Quarantine leave, in terms of being a fully paid leave by the employer, subsidized by the famous 350, is only available to those people who actually flew into Malta after the 12th of March and therefore had to stay in quarantine in Malta, not outside Malta. All right? Okay. Keep on going down the questions. Another question again is, when you say forced leave, do you mean forced leave up to end of 2020? What is there? Is no liquidity? Okay. What if there is no liquidity for that, in the company? Now, the thing is this. So, and this is where the IR changed its tack again from the beginning to the end. So at the beginning, the IR was saying, before you go on unpaid leave, you have to use up the accumulated leave that you have until today and give employees the credit up till the end of the year. That position has changed. Now, the IR is saying, for those who will be, for those who they permit to go on unpaid leave, it's saying you have to give the leave which has been accumulated up till now, but not going forward. So no credit till the end of the year needs to be given before the employees can go on unpaid. That is just, it is just an option, which needs to be proposed by the employer, therefore. Okay, sorry, we're back on. I just muted for a second. All right. There's a question from Daniel about parents. Parents who choose to stay at home taking care of children and therefore would be entitled to the parental benefit in theory? Are they automatically on unpaid leave? Now, so the concept which Lara was explaining at the beginning of the presentation still counts for basically most situations. The vulnerable persons, these parents, and basically everybody else. If the situation is actioned or is, let's say, brought upon by the employee himself or by the government, okay, with the exception of the quarantine leave, the employer does not have to suffer it, which means that in the case where the parent says, I need to stay at home, I'm sorry, then the next question which the employer needs to say is, can you work remotely? If you cannot work remotely, and then the employer can say, we can't pay you, you're not coming to work, we're obviously not going to fire you because you're not coming to work, but in the meantime, please do apply for the parental benefit to get something. Okay, and that is the whole idea. So the idea is that the government is supplementing the parent's wage rather than you paying it. So at that stage, from your point of view, the person can in fact be on unpaid. Obviously, you can come to a different arrangement if you want to, but that is the bottom line, and it is an option which you can take. All right. Another question is there a need to apply with the Labour Office, with the IAR, for a person or two who require reduced hours or unpaid leave when all the rest of the workers are okay? The answer is yes. Even for one employee, you would need to apply to the Labour Office. And you would need, technically, at this stage, if it's just one person, to get the consent of that person that you are effectively going to apply, okay? Rather than getting the consent of everybody. Okay. Now, there's a question in relation to what you would pay. What you would pay or rather, during the quarantine leave. During the quarantine leave, you are only bound to pay for wages, and wages is defined, and it is defined as base pay, okay, plus any fixed allowances, plus the government bonus, but it does not include anything which is linked with performance or production. Anything linked with performance or production does not need to be paid. So if it is a discretionary bonus, or it is a production bonus, or it is, I mean, technically even a commission, because that's based on sales, and those technically do not need to be paid during the quarantine leave. Okay. Now, there's a very good question by Sandra, which is, if a person is teleworking, can they also get the €800 benefit? Because these are two different benefits. The way that Malta Enterprise is working, even in conjunction with the Social Security, is that they effectively do not, or they are not accepting people who will get more than the maximum. What is the maximum? The maximum is €800 of benefits from anywhere for a full-timer and €500 for a part-timer. So the moment that one way or another, you effectively are going to exceed that maximum threshold, you will not get more than that, even though you could be eligible to get benefits from two different sources. Let's say you're getting benefits from the Annex B COVID wage supplement and also from the parental benefit. Oops, sorry. Then, I'm going down. A very good question from Sandra, thank you for asking it, in relation to casual employees. Casual employees are not, or rather, you would need to see the way they are registered with Jobs Plus. Now, although there are some doubts, they should be classified as part-timers. So technically, if the casual employment is the only source of income of the individual, then yes, the person should be open to get benefits. But the casual employment needs to be the main source of employment because, as I mentioned before, it needs to be linked with an NI. If you have a waiter who works full time with, let's say, island caterers, just to mention it, okay, and part time as a casual worker with Ganado, Ganado can't claim benefits for him, but island caterers can. But if the only job that this guy has is a casual job with Ganado, and the Ganado can apply for benefits, yes. We have also a question from somebody who's saying he's coming from an architectural firm. So our firm is not listed. Can we apply for some benefits and not others? You can apply definitely for the benefits, which are the social security ones. That is what your employee can go for. And you can go, obviously, for the quarantine leave supplement, blah, blah. But you cannot go for the COVID wage supplement unless you make a case. So you would need to make a case. I know for sure, though, that the Chamber of Advocates and the Chamber of Alperiti and the Chamber, or rather the MIA of the accountants is trying to get professionals or certain professionals even within the lists. So that is, being progressed as we go along. Right. Okay, a question from Julia. Relation to vulnerable persons. Is there a way that the vulnerable persons can stay home, claim for the benefit, and therefore they claim for the medical benefit, and then have another part of the basic paid by the companies, so that to guarantee full wage, so you would effectively pay the difference thing? The answer is no. The answer is that effectively the government is telling you that for you to go for the medical benefit, you have to have no payment whatsoever from the employer. Otherwise, the government is telling you, you get your money from the employer and leave me alone. That is the basic message, which I think makes sense. But of course, the government needs to stop somewhere, Julia. I think that's the problem we have. Okay. No. A good question here. If an employee who is on quarantine leave is teleworking, is the company eligible for the 350 grant? So the person who is on quarantine leave should be getting the full pay. Now, if that person is effectively open to working, I don't know, but maybe I have to check the rules quickly. But essentially, that person should be getting the grant, yes. I don't think there's an issue with that. Just double checking. Right. Again, we have a question from Mark Vella. Let me just, Mark, let me repeat. The top up, for you to get out of it, you would need to apply to the DIR. Once the DIR gives you the permission to go on unpaid, and these permissions are being issued, not something rare, right? In that case, you don't have to pay any top up. You simply have the benefits, and that's it. I think it is now pretty clear. I'm going to just give the mic to Lara so she answers 2 more questions.
I just need to find this. Okay, here there's a on. Okay, I start my video. Okay. There's an interesting question about probation. If we agree with the person to go on unpaid leave during probation to try to save employment, is the probation suspended during a period of unpaid leave, or does it continue to run? probation continues to run. So once, so if the person is on unpaid, the probation term keeps on running, and effectively, if the term passes, the employment will convert to indefinite, will become indefinite.
Something which we haven't tried yet, Lan, perhaps it's actually worth pursuing, is applying to the DIR to actually ask them to suspend the law for these people in terms of the probation. Technically, they can do it. So, you know, what I can say is that if you have these situations, might as well try. I think we should try, because you know, obviously, the alternative to the DIR saying no, we're not going to go for this means that, of course, the employee will you know, will actually lose his job. So what I can tell you is that via your legal advisor, please do try and, you know, and get permission to do this. We will see. I mean, how this will obviously evolve. It's not going to be easy, mind you, but we have broken the barriers before, so let's, I mean, do it again.
I had a question on maternity.
Okay, so let's continue. All right. We have a question from Andre. In the case of the medical benefit for vulnerable groups, are employers required to get an approval from the IR in case they cannot afford paying? So in the case of the medical benefit, as we already pointed out, this would need to be in place only if the employee is not receiving any funds from the employer. Okay, so the moment that that they stop receiving funds, then, you know, I mean, the medical benefit would kick in. The reply to your question is yes. For any employer to stop paying wages, you would need permission. You can't just simply stop paying wages. Okay, this is why I keep saying you start from the permissions and then you go on to benefits. Okay, a good question from Michaela, actually. So if the company falls under Annex B, in order to be eligible for the wage, for the COVID supplement, does it need to register a loss of more than 25%? No, the 25% rule is usually applicable for those companies who want to make a case. That's one of the elements which they need to prove. So effectively, what happens is that even when you go on the application form, the first thing you do is you put in your VAT number. That VAT number will then classify you under Annex A or B. Okay, it comes automatically. So the way that that works is that if you are under A or B, you are getting the benefits, and under A or B, you don't have to make any proof or case whatsoever so far. If you don't fall under A or B, the box under the VAT number will effectively say not eligible, which then means that you have to make a case. To start making a case, therefore, for the Molder enterprise to accept your application to make a case, you need to have 25% loss of cash flow. Obviously, you have to project this. There's no other way. Or you need to have a complete closure of your business, right? So that's where they start to basically think about your case. I hope that that will answer the question. But if you are under Annex A or B, no case is to be proven, you simply go for it. Okay.
Matt, I had mentioned the 25%, if you can hear me.
Yes, we can.
In the context of the deferral, the tax deferral.
Yep.
Arrangements, because you have to apply for those, and these are separate to the wage supplements, but to apply for those, you have to have had a significant downturn in turnover. And the example in the guidelines is a 25% loss of sales. But these are separate issues.
Yep. Okay, we have a very good question from Kimberly, effectively linked with maternity leave. And she's saying, when it comes to a vulnerable person, and that person is a full-time pregnant employee, then would the employer need to first, go for forced leave and then unpaid? Or is the employer still obliged to provide the paid leave before deciding or not to foot the bill? So the way that this system seems to be working is that the person can only go for the medical benefit if the person is completely unpaid, which means that technically you don't have to go for the vacation leave first. Problem being that if you apply to the Labour Office, as I mentioned, for the person to go for unpaid, they will ask you to go for the vacation leave first. So the answer to that is first on vacation leave and then on unpaid, because that is going to be the indirect result of your application with the DIER. Another important point which just came out on the recently today published FAQs of the DIER, which we have just read in 2 minutes, so please bear with me. But effectively what they're saying is that during maternity leave then, I don't know if you can check it out, but effectively during maternity leave, it seems that at that stage, the employer needs to pay the wages for sure. So for the pregnancy part, prior to the birth, it is basically leave and then unpaid. And then once maternity leave kicks in, you have to pay the full wage. Before the lockdown, sure. Let's actually show you the answer of the Labour Office, so it can be clear. I don't know if you are seeing it. Are you seeing it? Are you seeing it? Oh.
Wait. No.
Not seeing it?
No.
Okay, just a moment. You should be seeing it now.
Yes. Just
It's the very last question here, maternity. Okay, this is the new FAQs of the department. So, and you can see here, so when they start on maternity leave, you have to actually top up the difference between the medical benefit and the wage, is what they're saying. All right, I think that's pretty clear in relation to the maternity situation. Okay, then let me take this off because you're gonna. All right, going down your questions a bit more. Let's see what we have next. I'm sorry if this part is getting slightly boring, right? But of course we have to try to answer what we can here in the situation. Okay, I have already answered this question, but I want to repeat it because this is something which is very important. If there is still accumulated leave, but because of cash flow problems, you can't pay it, can the company force unpaid leave? The answer is absolutely not, in the sense that you have to apply to the Labour Office to effectively go for unpaid, and the condition is paid leave first. I know it's a problem if you're really strapped for cash. I'm sorry to say that the Labour Office will not give you unpaid until you go and pay your vacation leave. So far, again, things may change, but this is the current position. Okay. No, questions if you. Answer it. Tell me and go for it. Now, guys, there are many questions which are very specific to your particular case. Obviously, those I would to skip for now because it doesn't make sense for me to stay wasting everybody's time. Okay, I mean, I apologize, but this needs to be done this way. I'm sorry for that. Okay, we have a good question here, which I think we should go through. I received confirmation from the DIER just saying that I can put the employee on unpaid leave. I've given the employee a letter confirming the paid or unpaid leave, obviously, once you get the confirmation from the IR, is correct. We received info that those on unpaid leave are not entitled to the benefit. Is this correct? If you're meaning the COVID wage supplement and you do fall under the annexes A or B, the answer is they are entitled to the benefit. So this is related to the famous top-up story, okay? Forget that. If you are, and you have the permission, like you do have, to go on unpaid and your employees are under the annex A or B, you can, and you will, your employees will be receiving the benefit. No problem. Okay. Another question which is very common is, can an employer go for a 50% reduction of salary for certain employees whose work has been highly affected by the pandemic? Yes, but you can't make them work the same hours. So if you're going to go only for a partial reduction in wage for that section, you would need to apply for reduced hours. So you would say, for the section, I'm going to reduce the hours to 50% of what they should be working, in which case you're obviously paying half. And the Labour Office is effectively, should be agreeing to this once you apply, as we mentioned. I don't want to repeat the issue of the top-up because I have obviously further questions on this, but I think it's pretty obvious. Once again, no need for top-up if you get permission from the IR. This is important. All right. First of all, thank you for all the thank you messages. I'm appreciating them. So I, just thanks. Okay, I have a very good question which I would like to tackle because this is a question which is now being asked, as we go forward. We had one employee who was tested positive, and all employees who were in contact with him were asked to be placed on mandatory quarantine. What happens if these same employees are tested positive themselves due to local transmission? So let us discuss here the two categories: those who are actually they're infected with COVID-19, and those who actually came in contact and are temporarily asked to self-isolate. The same goes for those who are living with somebody who has COVID-19. La, I don't know if you wanted to take this. Give me a second.
I think that this, okay, I don't know if you hear me. I think the distinction is important. So if a person is actually tested positive for COVID-19, the person would be unfit for work and therefore has to remain in mandatory quarantine. For us, we would classify it as sick leave. The person who is also living with someone who is who tested positive for also needs to remain. Okay, so a person who tests positive for COVID-19 and is living with someone else, the other individuals need to remain also in isolation, and therefore we consider them that in the circumstances they are also unfit for work and sick leave applies. So this is one scenario. The other scenario where employees are actually asked to test for COVID-19, I would not and remain in quarantine at that point. Obviously, if they can work remotely, their wages would continue to be paid normally. If they cannot work remotely, then at that point, the employer needs to think of other alternatives. That is the use of accrued vacation leave or annual vacation leave at the option of the okay, and to force that, so to force the vacation leave and then to go on unpaid.
Thanks, La. Okay. Now, a very important question here, which is being asked all the time, because obviously, as employers, we are obviously concerned. Can we terminate by way of redundancy, I guess, or even otherwise? Let us look at what you can or you cannot do, okay? as an employer, if you have permissions from the IAR, during the livelihood of those permissions, you can make no one redundant. Not only the ones which you effectively have applied for certain measures, but the whole company. You cannot make anyone redundant for the time when the labor office permit is out. If you have not gone for any permits from the IAR, but you are going to claim benefits, then those people for whom you are claiming benefits cannot be let go either. Now, what can you do? The only form of attrition which you can have in this specific case is the person's on probation. Those can be stopped due to probation. Nobody will say anything. And unfortunately, I have to say this because it is a reality, and I'm very sorry for those like my dad who are following and who are 65 plus. But effectively, those who have reached pension age technically can also be stopped by the employer. All right. I don't want to pass the wrong message here, but this is the current position at law, and therefore these people you can stop without any issues. For the rest, you cannot make anybody else redundant. If you have somebody who has acted wrongly and you want to dismiss him for disciplinary reasons, that's fine. It has nothing to do with this whole scenario. So that you can always do. Okay. Going down. All right. Okay, I have an interesting question here from Madeline, which is a bit of a dangerous one. And I'll explain why. She says this. Regarding unpaid leave from the DIER, if the request comes from the employee, do we need to get authorization? And the answer is no. But, and I've had companies ask me this question, and I'm very wary of how I give the answer. If it is a matter of the employee saying, I want to be home with my children, I am a vulnerable person, I was told to stay home, and they have nothing to do with the employer, and then I'm fine. Yes, there's no permission needed. But the labor office is not going to be happy, and I'm saying this with hand on heart, if you decide to say that the employees voluntarily agreed to go on unpaid. There, I would definitely recommend that if you are hitting more than one person and you are going on a more widespread scenario, you actually do get permission, okay? Because as in here, we have to pay attention. I would always play safe in these scenarios because the labor office or even the employees may complain, and then you are open to criminal action in the future. It's a no joke. So, I mean, do be cautious. Okay. Very good question from somebody who is anonymous is, if a husband and wife are both working from home and are trying to do so remotely, but it's impossible for one to work remotely due to taking care of the children, not technically, but in practice. Can one apply for the parent benefit? No, is the answer. I mean, I'm in that situation. Me and my wife are both at home. We're trying to work. It's proving to be quite difficult. No, unfortunately not. I mean, look, let me be clear. The rules say that you cannot. Now, if one of the parents agrees with his employer to get a permit for him to be on unpaid, so be it. But that has to be done first. Okay, just saying for me it is difficult. I can work from home, but I can't because of my children is not something which would be accepted. All right. I am very wary of time, and I'm definitely going to stop in the next few minutes. Okay, but we'll just go through a few more questions. What I'm going to do, guys, and I apologize for those who are our clients, is that for questions of our clients, I'm not going to answer them now. Those we will be speaking to you privately about. But so I'm going to try and tackle some from the others, so at least they get something, well, something else here. Right. Okay. I have just a quick message for the person, and he knows who he is, who actually asked the Labour Office to extend probation, and they said you can't. Speak to me, please.
To extend.
Okay. Okay, let's see some more questions. I mean, just for information, guys, I have literally 104 questions. Obviously, I can't deal with them all, but I'm just dealing with the ones. I'm just scrolling down to see the ones which are best. Just for you to know, hopefully next week or we get some space. Not now, but it's really not the time. We will be having a specific webinar on redundancy per se. Okay, so redundancy and collective redundancy. That will happen soon. So I mean, don't worry if you have any queries now. My suggestion to you is that if you are going to make people redundant now, obviously contact us and we will guide you. Okay, a good question from Maria in relation to banking of hours. Does it need permission? The answer is yes. There's a regulation called the overtime regulations, and they in fact do require a permission to be applied. So yes is the answer. All right. We are getting to the bottom, guys, so I'll probably just answer perhaps one question.
No, someone. I just saw the question they
Wait.
asked.
Shoot.
Sorry, someone just asked whether you need an agreement in place for remote working, or whether a policy would suffice. In terms of the legal notice itself, which regulates remote working, you need an individual agreement with the employee, and also for the benefits. So where possible, obviously, the preferred option is to have an individual. Where this is not possible, it is acceptable to have a policy which nonetheless covers the information which you need to give to employees, which are set out in the legal notice on teleworking. So preferred option is an individual agreement. Where this is not possible because of volumes or because of the way we're working right now, a policy can be in place, but it should also cover the things set out in the legal notice itself.
Thank you, La. I'm just going to tackle two more questions and then we'll close because time is pressing. So the first question comes from Sandra. Thank you very much. Within the same company, can persons be put on shorter working hours, as in someone on a 3-day week, she's saying, and basically others working on longer hours? So now we have, even overtime situations. Or will you be discriminating? The answer is no, you won't be discriminating. But perhaps in that situation, the Labour Office will come back and tell you, do you have to reduce so much? Can you have a system where these people who have less work are helping the ones who have now more work? And if that is basically impossible because of license issues or some other case, then so be it. I don't think they will raise havoc on that one. The last question, which I'm going to answer, refers to third country nationals. And this is obviously of concern for everybody because there was a lot of mixed messages coming even from the Ministry of the Economy first, and then there was some confusion. There are some issues in the sense that work permits is a big problem, but now work permits are in fact still basically being renewed for a limited number of cases, but it is actually being done online. And if you have employees who are working with you, you can renew the permits. That's not a problem. Applying for new permits is hard unless you have a KEI. So watch out for that. And the KEI means somebody who's paid more than 30K and has particular roles. What I can tell you is that what can you do is the question when the work permit is about to expire. Well, people who have a work permit which is about to expire can be considered with all the rest. Doesn't mean that you have to terminate the employment because they're about to expire. Let's be clear, right? Let's not go away with the idea that these third country nationals are the sort of first ones that you shed. Some people have important roles with companies, and they should be treated in the same manner as other people on fixed-term contracts. If you are going to say, I shed third country nationals, but not the others who are Maltese, and those are also on fixed-term contracts, you may have issues. So watch out. What you can do to save their job, though, so if you do have a lack of work, and these are literally your supplementary stuff, they have a work permit, what you can do is you can apply for the Labour Office, like with the rest, and you put them on unpaid. This issue has not yet been, let's say, rubber stamped by Jobs Plus or by Identity Malta yet, though. But I would say that it is a remedy which one needs to look into. So you can actually put them on unpaid in the sense that you apply with the Labour Office, put them in the category, ask for these people to also be on unpaid, and if they let you, they should be also getting the government grants, and there you hopefully you keep them. Otherwise, you have the right to stop the employment on a fixed-term contract, you pay the penalty, let them go, and unfortunately, they have to go home. I think those are your two alternatives. So if the permit is effectively, just about to expire, you can renew. If you don't want to renew, it can expire, and then so be it. That is, that's always your option. All right. I don't have any more time today. I just would like to put Robert back on camera so he says bye-bye. I don't know if he's still there. Rob, basically, I'm so sorry to wait a second.
Oh, yeah.
I'm so sorry to keep you there listening to our boring employment questions, but we
Not at all.
for once you learn, not we learn. They say.
Not for once, many times.
Right.
Very often.
All right. So what I kind of say is thank you so much for those who actually attended, for those whose questions we haven't answered, and their clients will obviously try to contact you. If you have any queries, what I can say is please do send us an email over here at employment@GANADO advocates.com. I have no more voice now, and I hope I'm not going to go for testing tonight at this stage. So thank you very, very much. You've been great, and until next time. Cheerio.
Bye-bye.
Bye.